All right. So again, I'm an estate planning attorney, Leslie Sultan. And why is estate planning with minor children so important? Basically, legally, if something happens to you and the child's other parent and you don't have an estate plan in place, your minor children can be placed in foster care, and a stranger via the court would decide your children's future without any input from you. So estate planning is really important because it gives you, the parent, the ability to make your wishes known regarding who you would want to raise your kids. It's not enough to just go through, the church and appoint godparents for your children, right? That is not a legal procedure recognized by the courts. It could be taken into account, but really we have to prepare paperwork. If it's not in writing, it doesn't exist. So part of estate planning is planning for guardianship, raising children, both who's going to raise them and who's going to manage the money for them. So for some people, trying to figure out who you'd want to be the guardians for your children can be really hard. As a parent, you don't want to think about not being there for your kids, but if you couldn't be there, who would you want to raise your children and, love them as your own, as their own? So we don't want to let not choosing a guardian be a reason someone's not doing an estate plan. So today I'm going to ask you to fill out the workshop, the workbook. At least name somebody who, whoever comes to your mind. Okay, make a decision. We can always change the decision, right? This is just a workbook. It's not the legal document. It's not legally enforceable. But we want to at least get something in writing today. Then at least, you could think about it, sleep on it, wake up in the morning, maybe change your mind. But at least we want to get this going so we can move your plan forward. Some things to consider. You want one primary guardian, right? So a sister, a cousin, a friend, and then you want to name backup. So what if that person is not able to, at the time, raise your children? At least you can have backups in place. Okay, so this, of course, makes it harder. You're not just thinking of one person to raise your children, you're thinking of three people. But this allows you to, make sure that there's a contingent person in case something goes wrong. You can choose a couple. So, a friend and her husband. Just make sure you determine if you would want one to act alone. So if you're choosing your friend and her husband, are you okay with the husband alone if your friend is not able to? You can certainly choose relatives, close friends. Think about what's their parenting style, their moral values, health values, religious beliefs. How well do they know your children? Where do they live, right? Some people might be sending them to a best friend, but they're in another state. So we just want to make sure that, we are okay, we're prepared for that. The age of the guardian in relation to the age of the kids. So if you're choosing elderly parents who might only be older as we get, your kids get older, that can make it difficult. Are they good with money? Now, don't let whether that person who would ideally raise your kids not being good with money prevent you from naming them, because you can always appoint a third person to manage the money for the children. So that should never be the reason not to appoint somebody. And I'll go over that in a little bit in a few minutes. So are they good with money? Obviously helps. It's all one shot, raising the kids and taking care of the money, but it's not a requirement. You can have someone else pay for their needs while they're being raised by your favorite cousin. And then, of course, you're going to want to have a conversation with these people. Hey, I'm considering naming you as a guardian of my children. Are you going to agree to this role? Okay, so I'm going to give you guys a minute. Turn to the page in your workbook, or write down who would be your number one pick for guardians for your minor children, and who would be successor, and if that person's not around, a third successor. Okay, so that's the long-term raising people, raising raising kids into people. The other thing we want to do, which we provide for our clients, is naming short-term guardians. So what does this mean? For example, I have an aunt who I would love to raise my children. She lives in Canada. Okay, so that's not a problem for the long term, But if something happens to me and my kids are in school, she's not going to be able to fly over here in time to pick up my kids. And the school can't release them if nobody's there. So guess where they're going to wind up? They're going to call the police. The police are going to call Child Protective Services, and they could wind up in foster care until the aunt can come down from Canada, which is absolutely not what I would want. So I'm going to name short-term guardians, neighbors, relatives that live in the area, that if they get a call, they're going to go and pick up the kids and hold them until the aunt can come. Okay, so you want to, again, pick 3 people that you can that would be able to not necessarily raise them long term, but could hold them for a couple nights until the long-term guardian can come and get, to start to take care of them. Ideally, they're within 30, 60 minutes from where the kids might be, either the home or the school. Make sure they know your children well enough that you feel safe leaving them in an emergency with these people. And again, remember, it's just temporary, but it could be overnight, a couple nights. So, you want to think about this, but it's really important if you can name these temporary people, and with the thought that this list would be provided to schools or daycare or whatever it is. And then, of course, check with those people, make sure that they're going to be okay with this idea. So guardians for minor children, again, you want to make sure it's someone identified locally that can quickly get your children, to prevent Child Protective Services from getting involved and potentially removing the child until a guardian can be appointed. And we can also do guardian exclusion, right? So under no circumstance do I want this person raising my children. Let's put that in writing, okay? Because if that person tries to come in, maybe they think, oh, if I raise the children, I can get all the money, right? Whatever the reason is that you don't want them to do that, put it in writing. We can help you prepare this. And that would also go to the court. So if at some point they do try to make an application for guardianship, the judge can take your wishes into account and say, the mother did not want you to be appointed. I can't appoint you. All right, so here we are at the workbook. You're going to list the 3 people for short term. So I know this could be hard, just jot something down for now. You can always change it before we do the actual planning. The exercise here is making those decisions, going through this process. All right, if I'm going too fast, feel free to let me know in the chat. Otherwise, I just want to be respectful of everyone's time and keep this moving. Okay, so the next topic is a trust. And I love trust. They're my favorite part of the work I do. So what is a trust? A trust is a legal document. That's all it is, straight legal document. It's signed and notarized. And if it's done during your lifetime, or it goes into effect immediately upon your signing it. And it can also cover if I become incapacitated, other trustees can take over. And of course, upon my death, there's instructions for it transferring the assets to my loved ones. So the reason that we call it a living trust is because you create it during your lifetime. Just so you know, there's also something called a testamentary trust. Those are created through a will. Those are not preferred, especially in states like New York, California, Florida, where probate takes a long time, and I'll get to that in a minute, that you have to have the court basically create the trust. We're going to create it during our lifetime. There's 2 types of trusts, revocable and irrevocable. So a revocable trust is one where I'm the grantor and I'm the trustee. Okay, so the grantor is creating the trust. The trustee is legally responsible for managing the assets. And then it provides instructions for me to manage it for myself. I'm the beneficiary while I'm alive. And then upon my passing, it goes to my successor trustee, who then manages it for my successor beneficiaries. All right. An irrevocable trust is very similar, but it actually has more advantages. And the reason it does is because if I create an irrevocable trust, I'm the grantor, but I'm not the trustee. I have to appoint a third person to act as the trustee. And then I just become the beneficiary. So that trustee has to manage the assets for my benefits, and I don't control them and I don't own them anymore. And the benefit there is that I qualify for long-term Medicaid. So then if I needed to go into a nursing home, I would qualify because I don't own anything, and Medicaid cannot come after my assets to recover for the cost that they spent taking care of me. So ideally, people are doing the trust and they're funding it during their lifetime. So a trust is a will substitute. Everybody knows about a will. It's basically instructions for how you transfer your assets upon your death, but a trust works differently because it's a comprehensive approach. It manages the assets and avoids probate because wills are only for what is in my estate. But if my trust controls it, it's not in my estate. It's not even in my name. It's in the name of the trust. Janet Nation, who's on today, she has a great saying. She says, where there's a will, there's probate. And the reason that she says that is so beautiful because a will has to be validated through the courts. And that's the big misconception that most people don't know. A will, your family cannot take the will to the bank and say, give me my money. The bank's going to say, we don't know if this is valid. You've got to take it to the court. The court has to verify it, and then they can go back to the bank. In New York, that process could take 6 to 9 months, even longer in some counties. So it's a big problem for the families because now they don't have access to the money. They need to go submit it to the court. They might not even have money for attorneys. So trust is really important. The picture I have here is a wagon showing the girl has all her little toys in the wagon. So she's taken her toys and put them into the wagon. And then she's got the handle that she's going to carry to control all her toys. Okay. So the trick is you've got to put the assets into the wagon. You've got to put your assets into the trust. If it's out of the trust, it goes through court. Okay, so that's why she's crying on the floor. It's not serving the purpose it's supposed to serve. But as long as you fund the trust, that's the magic legal language, it avoids court because the trust does control it. I just have someone asking for the link, so give me 1 second. All right. All right, so I do see some questions coming in the chat. That's great. I will get to those in a few minutes. So in the meantime, again, I want to emphasize the benefits of the trust. It does provide distribution language, just like a will does. You can list your beneficiaries on your life insurance and retirement plans so that the funds go to here's the thing most people don't realize. Minors cannot inherit, okay? So if I were to name my children as beneficiaries on my life insurance and they're still minors at the time that I die, the insurance company cannot write the check to the minors. They can't. So what happens is it winds up going through the courts. And in some cases, the courts will appoint a court-appointed guardian for the money, which means anytime the person raising the children needs the money, guess how they get it? They have to go through the court to get it. And when the child turns 18, it's not like, oh, automatic withdrawal. They have to petition the court for permission to get their own money. It's a big hassle. So we really want to keep everybody out of court as much as possible. So the beauty of the trust is you contact your life insurance, you say, I want to name my trust as the beneficiary. They have no problem then writing the check to the trust. And then in the trust, you have the language for, I want this to go to my children. And you can set the ages for the distribution of the children, right? So the default is 18. Not everybody likes the idea of if I have $1 million life insurance policy, all of a sudden my kids at 18 can have access to $1 million and no parent to correct them on how they're spending it. So we recommend doing ages 25, 30, and 35. So they get a portion at 25, another portion at 30, balance at 35. All right, so again, it avoids probate if the trust is funded. That's the magic word, funding the trust. Provides for successor trustees. So if I'm doing a revocable trust, I'm in charge. I'm still writing the checks. I'm still owning my house. Everything stays the same. And then when I pass, it goes to my successor trustees who have instructions for raising my children with the money. Okay, and the best part about a trust too is it also can take effect if I become incapacitated, right? So my mom had a revocable trust. She also has now dementia. And me and my uncle, her brother, were able to step up and start managing her assets because she could no longer write checks. So it had that language in there, which was so helpful for us. We didn't have to go through the courts to get control of her assets. The other really great thing about a trust is you can leave money in trust for someone, right? So let's say you have a special needs child or someone with a disability. They either cannot receive the money because they wouldn't be able to manage it, or if they're on disability or government benefits and they receive a huge lump sum payment, guess what they're going to lose? Their benefits. So the trust can say, I want to hold the money for their benefit and continue to buy things for them, spend for them, but not give it to them directly. Therefore, they get both the government benefits and the inheritance. All right, trusts also provide tax planning benefits, but that's for the high net worth. And you can always change your trust, so it's not like set in stone. And although a trust does cost more than a will, the savings of avoiding the probate process is a huge benefit for families, because your family doesn't have to wait and pay money and hire attorneys to go receive their inheritance. So someone just put in a quick question, which was, what are the drawbacks to a trust, and are there tax implications? So there's no tax implications. A trust is like an LLC. It flows through to the individual. There's not necessarily any extra tax forms you're filling out, although depending on your accountant, there is one extra page that they're filling out. But all of the income is the same to you. So there's no tax consequence for setting up a trust or managing a trust. There's also no ongoing costs, right? You're buying the wagon, you own the wagon. You're not constantly paying to own the wagon, right? The only drawbacks I would say is you have to do the work now during your lifetime to fund the trust, right? You have to go to the banks, change the ownership of the accounts to the trust. You have to contact the life insurance, change the beneficiary to the trust. So you're doing the work now, but by doing the work now, we say a trust is a gift that you give your family because you take care of everything for them. You package everything up nicely and it's there, and they don't have to do anything later. So again, the main thing with the trust is you have to do the work to fund it so that it works, okay? Okay, so we talked about a will. Again, a will, when you have minor children, we're always also going to do a will because the will is the legal document to name guardians. All right. So you're going to say in your will, I want to name so-and-so to be the guardian of my children. And if there's a different person you want to manage the money, we can separate that in the will. Obviously, if you have a spouse or another parent, they're going to usually be the default guardian. But of course, I can tell you in my situation, I'm not with my children's father, and I would not want him to manage the money for my children. So I've appointed my own trustee who's going to manage the money for the children while he raises them. So I don't have a problem with him raising them, but he's not going to be allowed to try to control the money for them. Oops. Okay. So again, the will is important for estate planning with a trust because it allows you to nominate the guardians. But we don't like a will by itself because it does tend to cost more and cause more delays for the family, which in some cases can be very detrimental because you still have to pay taxes, you're still paying maintenance and whatever else to manage a house. That it can get complicated. If you're still debating, one thing I like to tell people is, let's break down what the probate process is a little bit. So the term probate literally means proving. It refers to the process where the decedent's will must be authenticated. And here's one thing that most people don't know. The probate court was set up for creditors. It was not set up for your family. Why? Because we have an economy that deals with the credit. And so we want lenders to lend money to people. And they're not going to do that if they know that when someone dies, they're never going to get their money back. So the probate courts were literally set up to manage the debt of people who die. And the creditors come first. and no family members are allowed to receive their inheritance until all the creditors are paid. Okay? So if you didn't know that, now you know. Another reason to stay out of probate court, the minute you file in the probate court, creditors get notice. They have systems that follow court filings. So the minute I file something, I start getting notices for my clients of who they owe their debts to. So they get you. And that's really unfortunate for families because, I just had a deal recently where the clients thought they were inheriting a house. They were excited to move forward, and a huge lien was slapped on the house. And it was hundreds of thousands of dollars. And that was for a debt that their father hadn't paid during lifetime that, of course, accumulated over time. Um, in New York, unfortunately, probate takes a long time. In states like Jersey, Connecticut, we don't necessarily encourage trust because probate's fast. They can generally get probate completed within a month, sometimes weeks. New York, it's impossible. It takes months, and depending which county, it could be worse. Right now, the Bronx is the worst. If you live in the Bronx, I'm sorry, it's going to be at least a year, if not more. Nassau is about 6 to 9 months right now. They've slowed down. Kings, actually, Brooklyn has gotten faster. They were the worst for a while. They've caught up, but so it's a big problem. And probate is public, so anybody can search and see a copy of your will or see how things are being distributed. So not everyone wants to, nosy neighbor Nancy and evil predator Paul will know what's in your estate. And that could be, a big thing for people that are private and don't want people knowing their stuff. I can go online and Google any celebrity's estate and usually get the information because it's public. Let's see. So the biggest thing if you do probate for a will, probate is it's guaranteed if you have a will, and your house has to go through probate. Funny enough, if you don't have a will and you only own a house, there's ways to pass that without going through the courts. But if you did a will, that house has to go through the courts. Obviously, the best way is doing a trust because it puts everything exactly where it needs to be. It puts someone in control. It saves your family time and money, and it avoids the court process. All right, I think I have that twice. Sorry, guys. Okay, so the bottom line, how do you decide if you want a will or trust? Every family's different. Part of it's going to depend on what are we protecting. Not every asset can go into a trust. So if all you have is a teeny tiny bank account and a retirement account, a trust might not be for you. But if you have minor children, it's huge recommendation because you can set the ages for the children. If you have a business, that business cannot run if the owner dies. So if you have a rental property, forget it. Nobody can collect rent. There's no legal authority for you to collect rent until it goes through the courts. But if we put the company into the trust, guess what? The successor trustee can immediately take over and start running that business. So I'm a big fan of trust day in, day out. But most importantly, it avoids probate and your family gets all the benefits of the work that you did. All right, so now we're going to go into who are you going to pick for a trustee or an executor or both. You're going to want to pick at least one person to be the trustee. You can do co-trustees, but remember those co-trustees have to sign the checks together, right? So we don't always recommend co-trustees unless you really need that like accountability for the people. Because they each have to sign a check. They each have to go into the bank together. All right, definitely want it to be someone you know and trust and whose judgment you respect, they'll honor your wishes. Obviously, a trustee is managing money, so you do want them to have some financial background, not risky and all that stuff. You might really, really love your best friend, but that doesn't necessarily mean she should be a trustee of your assets. And if you can't think of anybody, but you really love this idea, there's a lot of companies, corporate trustees that do it for you. Okay, so Charles Schwab, Merrill Lynch, there's a ton of them out there. They do take a fee, right? So that has to be kind of, maybe something is like your last resort. Sometimes people will do, okay, my best friend, my sister, and then corporate trustee, because that at least it's going to get done. All right. So, and if you're considering someone, you do want to have that conversation with them. So part of setting up a trust is you're going to name your trust. It can be any name you want. Some people do. Oops. Um, Mine is the Sultan Loving Trust. You can also do the Sultan Family Trust or the Sultan Living Trust. You could do a nickname like the Golden Gate Bridge Trust. I've heard people done their pets' names. And then for the purpose of the workbook, which type of trust are you going to be doing? Is it a revocable where you're the trustee, you're pulling the wagon handle, or are you looking for long-term care for maybe mom and you want to do an irrevocable trust so that she doesn't own anything and she gets all the benefits of Medicaid? Okay, so you're going to pick a primary trustee, right? Number one. And then, of course, you want to do backups because in case something happens to that person, you don't want to come back and keep having to update your trust, right? There's fees involved to update your trust. You have to hire a lawyer to draft the document. So ideally, you're going to put, primary, option 2, option 3. Same for executors. So executors are the people that are going to do the will. When we do a trust, we only create a pour-over will, which says all of my assets should go into my trust. Okay, it doesn't have the distribution language for I want my assets divided equally among my children, because that's in the trust. And we want the trust to control everything because, like I said, minors cannot inherit. If you have someone with a disability, the trust has all that juicy language to protect your beneficiaries. But you do want to add, of course, executors, because if we're going to name guardians and anything accidentally stayed in your name, right, outside the wagon, we want to make sure they have the power to go and put it into the trust. So I'll give you guys a minute to fill that out, and then we'll move on to power of attorney. Someone asked a question. So if mother and father are separated, never married, and both create their own estate plan, but the plans and the terms of the guardian are not the same, can one plan override the other, and what makes that determination exactly? So good question. I mean, ultimately, it's going to depend on who dies first. I'm sorry, who dies last. Okay, so if one dies first, as long as the other parent has not been ordered not to raise their children, there's no order against them raising the children, the other parent is going to do that. If mother and father are not married, then they each probably have accounts in their own names, right? So he has his money in his name, so the estate plan is going to manage his money. She has her money in her name, her estate plan manages her money. So they can totally conflict. They can each appoint totally different people to manage their money. The only thing that's the same is the beneficiaries, the children. So, it might be that if both of them die, the guardian is going to one person for money and another person for money. So, if they're communicating and talking, it would be helpful if they pick the same person, but it's absolutely not required and it's not that big of a burden, for the families. So I wouldn't let that be a reason not to do estate planning. Okay, so power of attorney. So power of attorney is a wonderful document. Okay, if you haven't heard of it, I'm going to give you a brief explanation. It's a legal document that gives an agent of your choosing the authority to pay bills, make financial decisions, manage investments, file tax returns, mortgage, sell, buy real estate, everything legal and financial. Okay, in the event that you become incapacitated. So for example, my mom, she's lost capacity. If I ask her what date it is, she'll start with 1990. She's no time reference. She cannot write a check. She cannot manage her money. So we have to manage it for her. And because she did a power of attorney, we're able to do that legally. I can go into the bank, I can withdraw all her money, I can move it into a CD, I can mark, grow it, whatever I need to do as her power of attorney. And now I'm paying her bills and managing her money. Power of attorney is so important because if you don't fill out this one simple document and you become incapacitated, your family has to go through court to get that authority. And it's called a guardianship proceeding here in New York. And it is terrible. Okay. It's expensive. You're talking about lawyers, lawyers for you, lawyers for mom, court evaluators. It's so invasive. People are coming into the house. They're looking at all the finances. They're questioning medical bills. It's an awful process that you would never want your family to have to go through. So if you're here as a parent and your parents are still alive, it's a really important conversation to have with them. Are they willing to sign a power of attorney for, and have someone manage it? Because it's amazing what that one document can avoid. And we're talking about like, hundreds of dollars versus thousands of dollars, an instant process with the bank versus months of delays. Okay. So you might have heard about some guardianships, what's her name? I can never remember the names. Wendy, and then who's the other? Not. Anyways, yeah, there's some famous celebrities who have unfortunately been in the media about.
Yeah, Wendy Williams.
Yes, thank you, Wendy Williams. Thank you. And it becomes public. It's awful. So we want to avoid that. And the person can be a stranger that absolutely does not know the family. They never met the alleged incapacitated person in their lives, and they're going to be making all those decisions. And they also get paid, right? They get paid out of the money that's left. So it's really not the place that you ever want your family or loved ones to be in. So if you do nothing else, I recommend doing power of attorney. And so who do you pick for power of attorney? You want to pick at least one primary again and one backup in case that person's not available, right? Because you might do this today, you might not do it again for 20 years. So you want to make sure that those people are going to be there for a while. Usually when people are married, they're picking their spouses, but it's not required and it's not automatic. A spouse does not automatically get to be the guardian. Okay, they have to make a petition. They have to prove to the court that they're qualified. So obviously you want someone you know and trust. Hopefully they have some financial skills, right? Because they're going to be managing your assets for you. And if you don't have someone, you can choose a corporate fiduciary. And then, of course, have the conversation with the people, make sure that they're willing to take on this role. We don't use what we call springing power of attorneys very often in New York, but you can also have it only go into effect when there's an incapacity. So the power of attorney document is very powerful, right? If I sign one today, my agent could technically take that to the bank and go and access my money without my permission. So you don't want to create this and then like give it out to people. You want to keep it safe, make sure that it's someone knows where it is if they need it. But you really want to pick someone that you trust. All right, so go back to the workbook, list your agents, pick those two people. If you want, you can also do co-trustees, right? So there is that kind of accountability that someone can't do it without the other. Just again, they have to be kind of in the same place, right? You can't have somebody in Arizona co-trustee or co-agent with someone here in New York. That's difficult. All right, we don't want to make these things impossible for people. All right. So I'm moving along, assuming that we've done power of attorney. Now we're going to go with the healthcare. Similar concept, right? If I'm not able to make healthcare decisions, who's going to make those decisions for me? Who's going to decide where I live? Who's going to decide what medicine I take? That's a healthcare directive. So again, you're going to name an agent. Usually the forms for healthcare agents also give them authorization to get HIPAA authorization, so access to medical records, because of course, how can they make decisions if they don't have access to the medical records? So that's a really great document. All of our estate plans come with all of these documents, so it's a full comprehensive package, because again, we want to make sure people are fully protected. So again, who you're going to pick. You want to pick one person and then an alternative. Anyone you trust, maybe someone with a medical background is a great person. So you might say, well, my husband's going to manage my finances, but my cousin who's a nurse is going to be the healthcare proxy. So yeah, so let's fill that out. Usually the HIPAA agents are the same people for the healthcare agents. but you could put additional people that maybe you want to have access to the information that could help interpret it for the healthcare agents that they're not necessarily the healthcare agents. All right, so take a minute, fill that out. Oh yeah, Britney Spears. Thank you, someone in the chat put that in there. I don't know why I can't remember her name. All right, so yeah, guardianship, Britney Spears. All right. Okay, so end of life care decisions. All right, we're going there, guys. So one of the things you have to decide is, do you want to be cremated? Do you want to be buried? Do you want to leave it up to your loved ones, right? The most important thing is that if you want something specific, you want to put it in writing. Again, if it's not in writing, it doesn't exist. I tell the story of when I was 15, my dad died. Okay, I was very young. 6 months before my dad died, he had a heart attack, a minor heart attack. So, of course, he was thinking about these end of life things, and he sat me down and he said, Leslie, if I die, I want you to know that I want to be cremated. I didn't even know what that was. He had to explain to me what cremation was. 6 months later, he died. And my mom said, okay, we're going to bury your dad. And I said, but my dad doesn't want to be buried. He wants to be cremated. And she says, how do you know? I said, because he told me, right? Most people don't think to talk to the 15-year-old about it. I get it. But I had the honor of knowing that what my dad's wishes were and being able to voice them for him. And so I'm really grateful that he did have that conversation with me. It's really important that you have these conversations with your loved ones because you don't want them having the anxiety and frustration of not knowing and having to either fight about it or make decisions that they don't know the answer to, right? So I know these can be very difficult conversations. If you can't have the conversation, you put it in writing and you put it with your binder and your estate plan so that they'll find it. Hopefully not too late. Okay, so those are really big things. Of course, you can say, you know, I want to be cremated and my ashes thrown in the ocean. All of those wishes can be put down on a document. And then, of course, there's what we call a living will, not to be interpreted, not to be with the last will and testament. Okay, so the last will and testament is your will distributing your assets. The living will is how you want a decision made if you cannot make the decision yourself and you're in a vegetative state, and whether or not to pull the plug, basically. Okay, so choosing to prolong your life is I want to be kept alive on a respirator or on a feeding tube, and or choosing to withdraw it. Okay, so you have to make that choice, and it's a hard choice, but the point is you want to communicate it to your family, have the conversation, or do a living will that documents what your wishes are. Okay. So now in the workbook, you're going to pick one of those, and then for additional estate planning considerations, one of the things someone's asking, can you make conditions like extend my life if or not? Okay, so first of all, thank you for that question. We can't kill you, right? So if you're alive, but you're, we don't have euthanasia, right? The doctors can't say like, let's just pull the plug, right? It has to be like vegetative state, no sign of coming back. I mean, there's liability there. So they're not going to just be able to pull the plug. Ultimately, if you can specify to your agents, keep me alive as long as possible in case there's any hope, but once there's no hope, then you can cut me off. Or you can just not sign the living will and just say, I leave it up to you. I trust you to make that decision when the time is right. And then again, but it's having that conversation that makes it so valuable for your family. All right, so when you do your estate plan, one of the things to know is that the main language says the residuary, right? Everything goes to my children, okay? But some people might want to give a little bit of money to their church or their favorite charity or their best friend, whatever it is. A specific gift has to come off the top and it has to be specific, right? So you're going to start with that. So my diamond ring, I want that to go to my cousin. I want to make sure the Rolex goes to my son. Whatever it is, has to specify. If you don't put it in there, it's not enforceable. Okay, people could fight about it. So anything specific should go into your estate plan in writing. The other thing you want to do is, what if that person's not alive, right? So I'm going to give everything to my children, but if they're not alive, where do you want it to go, right? So you've got to think through some of these steps, as awful as it sounds. Okay, so again, so you're doing basically like a backup beneficiary, right? So we generally like to say, okay, everything to my children. If my children aren't alive, to their children, but if they're not alive, it goes to the sibling, the remaining siblings. So in this part of the workbook, you're going to write down any wishes that you have. This is really good for a trust. It's not so good for a will. I'm just going to tell you, I had a will recently where the person listed like all the furniture, like this lamp goes to this person, this couch, and it was a nightmare because now all of those people have to be notified and come to court and sign documents, and nothing can be released until all of those people sign. And what if we can't find someone? I mean, the will was written a long time ago. So if you're going to do a will, I would avoid a lot of specifics. If you're going to do the trust, that's a place to do it. Um, okay. And so again, so I think I did this already, but again, an additional estate planning considerations, again, thinking through who's going to receive if the first person you want is not alive. I'm dealing with an estate right now where three sisters own a house together. One house, three sisters. One sister made a will and she left everything to her nieces and nephews. Unfortunately, they were minors at the time. Um, so there's five nieces and nephews, and essentially now the two remaining sisters now co-own the house with these five children. Do they want the house? No, they want the money. They want the value of the house. So this is wound up in court and it's creating this huge problem. It's certainly not what the sister wanted, but she didn't think through some of these steps. And when there's minors involved, it can get very complicated. So again, if you're thinking about multiple beneficiaries, you really want to speak to an estate planning attorney. We have seen when things go wrong, we can kind of re-guide you and construct it better than, if you were to download a trust online or, put in these wishes. So, anyways, if you have any questions that have come up, any notes that you don't want to discuss today in the meeting, put them on here, send them to me. I'm happy to go over that. But also just in general, like, maybe I want my kids to know I have a safe deposit box and what's in there, which of course I do not recommend safe deposit boxes at banks. They are a total probate nightmare. Nobody's allowed to get into them when they die. Do not do estate plan. Do not put your valuables in an estate plan. I'm sorry, in a safe deposit box. All right, I've got a couple more questions, so let me just get through this real quick. So just so you have an idea of what the estate planning process looks like for us, with us. So we do an initial meeting. We like to look at all your assets because we want to know what we're protecting. Is it a house, bank accounts, retirement? What's there? It's because the more we know, the more we can help advise, right? Help prevent these problems from happening. So we do the asset spreadsheet. You send it back to us. We have the family planning meeting. So that's step one. Step two is we go through all the information with you. We figure out, do you want a revocable or an irrevocable? All of our estate plans are done on a flat fee basis. So you're not going to be wondering how many hours am I billed for this? And we go over the plans with you up front so you know exactly what you're paying. No hidden fees. After that, we do the drafting. So we get all the information, who's the trustees, who's the beneficiaries. We send it to you to review, and then we draft the documents. We send you the documents to review, so you've had an opportunity to really see them. There's a lot of legalese in there, I'm warning you, but you want to see them a little bit first before you sign the documents. It might be the only time you look at them. I have a lot of clients who are like, I never looked at them after I got them. Big mistake, but whatever. And then finally we do everything through a secure portal, and then we schedule the signing ceremony. That's done in person. We have witnesses, notarization, and usually people feel like, whew, like I've got peace of mind. It's a huge weight lifted off of them because that estate plan is finally done. Everything's in writing. Protections are all in there. Now, we recommend a 3-year review. So every year you want to, I mean, every 3 years at least, we want to check, did somebody have a baby? Did somebody pass away, get divorced? What could be changed in there that we don't like anymore? Maybe nothing. Maybe we're just going to wait another 3 years, but we definitely want to have you come in and review it. There's no charge for the review, but at least you're doing it yourself, reading the documents, making it sure it still works for you. And the bonus today is that if you took the time to be here, which I thank you for, and you're going to fill out that workshop workbook, if you send me that workbook, you've basically saved me like a half an hour of explaining all of this to each one of you individually. I'm going to give you a discount. So if you send me the workbook, I'm going to send you the asset spreadsheet. We're going to schedule a meeting. You got to do it before the end of the month. I'm going to give you $1,000 off a trust plan. Okay, I only do this once a year. So it's holiday time. I'm in the gift giving mood. So that please take advantage of the discount. But you do have to send me the workbook filled out because that's where I'm saving time on not having to go through all of those things with you all over again. And then of course during the planning session we'll firm everything up. But that's the offer for today. I hope some of you guys take me up on it. I am going to turn off the recording now and take questions, and I do have some in the chats. So again, thank you all for being here. Send me your workbook, get your $1,000 discount off the trust plan, and I look forward to seeing you guys before the end of the month. All right, so I'm stopping recording now.